let's listen in because this is live on camera. Let's tune in to what's happening into the Supreme Court right now.
We are unable to agree with the view of Justice Bhushan in the 2019 split verdict. As indicated previously, the majority decision in the 2018 Constitution Bench judgment rendered a broad interpretation of Article 239AA3A to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase "insofar as any such matter is applicable to Union territories" does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase "insofar as any such matter is applicable to Union territories," we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner to limit the legislative power of NCTD on certain subjects in addition to already excluded subjects in List 2. Article 239AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, Subclause A of Clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, Subclause B of Clause 3 clarifies that Parliament has the power to legislate on any matter for a Union territory, including on subjects with respect to which NCTD has legislative power under Article 239AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239AA, and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239AA3 balances between the interests of NCTD and the Union of India. Article 239AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. When we explain the entries, thus the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase "insofar as such matter is applicable to the Union territories" as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate.